In Chapter 5, we're going to talk about diversity, equity, and justice for all. Diversity is not simply a box to be checked. Rather, it is an approach to business that unites ethical management and high performance. Business leaders in the global economy recognize the benefits of a diverse workforce and see it as an organizational strength, not just a slogan or a form of regulatory compliance with the law. They recognize that diversity can enhance performance and drive innovation. Conversely, adhering to the traditional business practices of the past can cost them talented employees and loyal customers. Attracting workers who are not all alike is an important first step in the process of achieving greater diversity. However, managers cannot stop there. Their goals must also encompass inclusion or the engagement of all employees in the corporate culture. Workplace diversity is not a new policy idea. Its origins date back to at least the passage of the Civil Rights Act of 1964. In 1964, the U.S. Congress passed this comprehensive civil rights legislation, and for the first time, it addressed discrimination in the private sector, banning it in the public sector, such as hotels and restaurants, in federally assisted programs, and in employment. The Fair Housing Act of 1968 extended protection against discrimination to rentals and home ownership, and Title IX of the Education Amendments of 1972 banned discrimination in education on the basis of sex. Title VII is a federal statute that prohibits employment discrimination based on race, color, religion, sex, and national origin. Title VII has been interpreted as banning not only outright differential treatment, but also practices that appear to be neutral, such as height and weight standards, educational requirements, but which just proportionally disadvantage members of one race, sex, or religion, which is called disparate impact. In general, Title VII seeks to eliminate employer and union practices that discriminate against employees and job applicants, again, on the basis of race, color, religion, sex, or national origin. It applies to the hiring process and to discipline, discharge, promotion, and benefits. The Supreme Court of the United States has created, and also another Civil Rights Act of 1991, has two theories of discrimination. The first is a disparate treatment claim, which exists where an employer treats some individuals less favorable than others because of their race, color, religion, sex, or national origin. Proof of the employer's discriminatory motive is essential in a disparate treatment claim. So a disparate treatment claim would be if an employer refused to promote a certain group intentionally, like African Americans. Disparate impact, on the other hand, exists when an employer's facially neutral employment practices, such as hiring or promotion, examinations, although neutrally apply, which means everybody has to take them or they occur for everyone, cause an adverse reaction to a specific group or a disparate impact to a specific group. In addition, the employment practice in question is not shown by the employer to be job-related and consistent with business necessity. Under disparate impact theory, it is not a defense for an employer to demonstrate that it did not intend to discriminate. That's not a defense because it is the impact. Title VII protects against sexual harassment. What has been called quid pro quo harassment, sexual favors in exchange for something concrete, such as a job or a raise, is easily identifiable as illegal sex discrimination, and employers are automatically responsible for such tangible employment retaliation. Much harder to define, however, and far more controversial are situations involving what has come to be known as a hostile environment, which is sexual harassment. And to make out a prima facie case of hostile environment for sexual harassment, the plaintiff has to show that they are part of the protected group, They have to show unwelcome sexual harassment, and they have to show that the harassment occurred because of their sex, and the harassment was severe or pervasive, to alter the terms and conditions of employment. Sexual harassment can occur even if it is not a female. So sexual harassment, if a male had a female boss, he could be sexually harassed. Or it can also include working for a boss of the same sex. So same-sex sexual harassment can exist. So that's something to think about with sexual harassment. Racial discrimination is actually, you're protected against racial discrimination and also harassment under Title VII. And one of the cases that looked at disparate impact, which I've discussed, deals with, and your book doesn't talk about it, but I thought it was a good case to kind of show disparate impact. It's an older case. African American workers at Duke Power Company in North Carolina sued the company because of a rule that required employees who were transferring between different departments to have a high school diploma or pass an intelligence test. This case here is a Supreme Court case. So everyone had to have, in order to get promoted, a high school diploma or pass an intelligence test. However, the impact is that less African Americans were getting hired for the job or promoted because of this test. It was shown that the intelligence test had nothing to do with the job. So this is where the Supreme Court said that if you're going to give employment-related jobs, it has to, if you're going to give if you're going to give tests for employment, you have to give employment-related tests. So in other words, if you have a job test being given, it has to relate to the skills that you're going to have in your particular job. That was a tongue twister. Hopefully that made sense. Religion. Title VII protects you against discrimination because of your religion. To establish a prima facie case of religious discrimination, the employee has to show that he or she holds a sincere religious belief that conflicts with the job requirement. He or she informed his or her employer of the conflict, and he or she was disciplined for failing to comply with the conflicting requirement. Once all factors are established, the burden then shifts to the employer to show either it made a good faith effort to reasonably accommodate the religious belief, or such an accommodation would work or cause an undue hardship on the employer and its business. Title VII religious discrimination claims often revolve around the question of whether the employer can show reasonable accommodations would cause a work or hardship for the employer. National origin. The EEOC has rules on English-only rules in the workplace. So if you have a workplace that says you can only have English spoken, an English-only rule that applies at all times is considered by the EEOC a burdensome term and condition of employment, which is in violation of Title VII. However, an English-only rule that appears only at certain times, so not at all times, does not violate Title VII if the employer can justify the rule is needed for business necessity. Legislating family leave. The Pregnancy Discrimination Act is an act that states that an employer cannot dismiss or refuse to give work to a woman because of her pregnancy. So pregnant workers are supposed to be treated just like disabled workers. If you make accommodations, you should make reasonable accommodations as an employer for someone's pregnancy. If you're going to make accommodations for someone who's disabled, which you're supposed to under the law make reasonable accommodations, you should do the same for someone who is pregnant. The Family Medical Leave Act of 1993 it states that eligible employees shall be entitled to a total of 12 work weeks, but it's unpaid leave under federal law. Some states actually give paid leave, but the reasons could include a birth of a child, adoption of a child, in order to take care of a spouse, a child, a parent of a particular employee, or because of serious conditions that the employee has that makes the employee unable to perform their particular job, or because of a qualifying exigency or emergency arising out of the facts that the spouse or the son, daughter, or parent of the employee is deployed overseas in the armed forces. Reasonable accommodations should be made for disabled employees. The Americans with Disabilities Act makes it illegal for employers to discriminate against a qualified person on the basis of a disability and requires firms or employers to make reasonable accommodations. In 2008, Congress amended the ADA to overturn the Supreme Court decision that had narrowed the scope of protection that the act was intended to offer. And as amended, the law requires courts to construe the definition of disability broadly. So it allows for a broad interpretation. And this clarifying that, it means that a person meets the definition of disabled if he or she has any impairment that substantially limits even one major life activity, and even if their disability is episodic or is in remission. So there's a broader definition of disability because of Congress's amendment to the ADA in 2008. Equal protection is a constitutional clause of the U.S. Constitution, and it rests on the central notion that the government must be fair and reasonable, not arbitrary. And similarly situated people should be treated the same as what the Equal Protection Clause of the Constitution says. Strict scrutiny has been applied in suspect classifications, such as race and ethnicity, and in cases where the classification infringes on a fundamental right, such as the right to free speech or religion or the right to vote. So if the discrimination involves a suspect classification where strict scrutiny is applied, then that means that the law involved has to serve a compelling state interest, and it has to be narrowly tailored. That's the standard. Affirmative action plans are only allowed if they are needed. For example, if you have some type of disparity, and the disparity looks at, in determining whether there's a disparity, you look at the community at large. So if you only have 2% African American, as managers, but you live in a place where there's only 2% African Americans, that would not be enough to show a disparity. If there is a need for affirmative actions, it should only last for a reasonable period of time to correct the disparity.